Thank you, boss. That's right here.
Do you want me to try to make this work?
There's just no water. No, and I don't want to drop it because I'd be in hot water with the boss.
We won't, Millennials and their technology.
So excuse me for looking down. So I'll skip the introduction. Again, I'm Erika Reynolds. It's great to be here today. I appreciate the invite. Can you skip the
Do you want to click your own, or do you want me to click it?
I'll click it.
Okay,
Thank
so
you.
that one to go forward, that one to go back.
Okay, thank you. So the easiest way to break down my job is there's two separate categories of crimes that I prosecute. The first being sexual or physical in nature, and then the child pornography portion of my job. The sexual and physical in nature, I typically take the sexual abuse cases. There's a prosecutor in our office that does physical abuse cases when it's related to a domestic violence situation. So I usually try to stay out of that by design and stick to just the sexual in nature allegations. And then there's the child pornography. In dealing with the sexual and physical abuse cases, I work through really closely with the Children's Advocacy Center, and I'll explain that in a little bit more in depth here in a little bit. And then with the child pornography cases, we work through the National Center for Missing and Exploited Children. There's a task force that's been created with law enforcement, and I'll explain that in a little bit more depth here in a little bit. But those are the two agencies that I essentially, or entities that I work with in order to prosecute these crimes. Starting with the Children's Advocacy Center, these are all the different people that are on the multidisciplinary team that our office is involved with. There's the team coordinator. That individual is responsible for setting up trainings, running meetings, setting up interviews that go through the Children's Advocacy Center. We have the Children's Advocacy Center in this county within the health department. That's by design, away from the police department. And that's where we essentially take children to be interviewed so that they can tell their story about the allegation that's been brought to light. And I'll explain that in a little bit more detail. Then there's the victim advocates. They're essentially the communication line between law enforcement or the prosecutor's office and the caretaker of the minor victim. They attend all of the interviews that pertain to the case. They take note of the allegations. They will notify the caretakers of resources available. To give an example of that, oftentimes, sadly, the allegation is typically against a paramour of the mother of the children, and that's the most common allegation we see. And that usually is an individual that is financially responsible for their situation, so that complicates things for the mother of the alleged victim. And so in that situation, the CAC has resources to get them into a shelter if necessary in order to avoid putting the child back into that environment. They're responsible for notifying the caretakers of where the case is at as it progresses through the process, and I'll get to that a little bit more. And they field questions from the caretakers, and honestly, it cuts down on a lot of communication and answers that I have to give about where the case is at and updating and stuff like that. And so they kind of are my right hand, and I work closely with them. The forensic interviewers are the individuals that are responsible for interviewing the children. They're trained individuals. They have to be certified in the state in order to interview a child. And in our county, we have a couple that work within the CAC, and then we have law enforcement officers that are also trained to do that. There's DCFS caseworkers, and I'm sure you guys are aware they're responsible for the safety of the child if the offender is in a caretaker role. There are therapists that are employed through the CAC, and they provide therapy to everybody who is interviewed through the CAC, whether or not that's an actual victim. That could just be a witness to something, and they are there to provide free of charge to anybody who's interviewed at the CAC. In order to be interviewed at the CAC, you have to be a minor under the age of 18. Otherwise, the police officers are going to be the ones that do the interview through your traditional interview process. The Pediatric Resource Center, a lot of people don't realize that this exists, but there's a pediatric doctor in Peoria, which sits on the team. And that's somebody that we communicate with regularly. They do physical examinations for any serious physical abuse or suspected sexual abuse. Whenever there's an allegation of any type of penetration, the child is automatically referred to the Pediatric Resource Center for a full body exam. Law enforcement is all obviously on the team. They're the investigative body, as I'm sure you can guess. And then the prosecutors, saving the best for last. We're in charge of charging the case and trying the case if it ultimately goes that direction. So a way a case goes through this Children's Advocacy Center is there's a report of an abuse. Typically, this report comes through DCFS or through law enforcement. That is most often through the school. A child will report to somebody at the school, or the school will take note of something that's going on, and they will report to DCFS or law enforcement. It's important to note that most disclosures are delayed. It is rare that a disclosure happens immediately. Typically, it's delayed by months, if not years. Then the child is interviewed at the Children's Advocacy Center. The child is brought to the Children's Advocacy by a non-offending caregiver or by DCFS. It's important to note that sometimes the community gets frustrated with law enforcement because they're not like snatching this kid and taking the kid to be interviewed. Law enforcement has zero authority to do that, and so it has to go through DCFS if we don't have a non-offending caregiver that's participating in the investigation. While at the CAC, there is a waiting room, there is an interview room, there is a playroom for the kids, and then there's an observation room. The interview room is set up in essentially like your living room would be. There is a recording device in there that the child is notified about, and then there's an observation room where people that are on the team will be in another room observing what's happening in order to give feedback to the interviewer or to get some of the questions that I want asked or some questions that DCFS may need to be asked. And so we can communicate with the interviewer while they're in the interview room. The environment is kid-friendly. The idea is to make it a situation where a kid feels comfortable disclosing anything that may or may not have happened to them. The questions are non-suggestive and allows the child to give a narrative answer. So it's important that we ask questions in which elicit accurate responses. And so we don't ask any leading questions. We don't make any suggestions to the children. We're asking them questions so that they feel comfortable making a disclosure if anything actually happened to them. Like any other case, we ask questions like who, what, when, where, and how. One of the questions that typically gets asked of them is to give us some type of ideas when this happened. With kids, as you all know, time is not something that they necessarily have a grasp on. Like any kid that gets into a car to go on a trip somewhere, it's inevitable within 20 minutes they're asking if they're there yet, even though you have an 8-hour drive in front of you. So we don't ask questions like how many times did this happen? Did it happen one time or more than one time? What season was it? What were you wearing, to kind of try to narrow it down? Were you in school at the time? So that we can have a more specific time frame. We ask questions like your surrounding. If a child alleges that a perpetrator sexually assaulted him in his apartment and she has no business being in his apartment, then we ask questions about, well, what's his apartment look like? So then later that's something that we can possibly corroborate. through the investigation. We'll ask about body markings, if there are piercings or a mole that they shouldn't know about because of the place that it's at on the body. Facts the child shouldn't know. It is in itself corroborating for a 5-year-old to discuss a sexual assault in detail that's consistent with the common experience of what a sexual act looks like, and if they do that with kid-appropriate language. A 5-year-old has no business knowing about certain things. I mean, most 5-year-olds think that you can get pregnant from kissing. So when they talk about sexual acts, sometimes that's in and of itself corroborating evidence. One of the examples that I always like to bring up, it's graphic, but there was a child that was interviewed and she was asked to give a description of what happened. She indicated that he had ejaculated, and she used a different term. I don't remember exactly what it was. But when asked to describe what that looked like, felt like, smelled like, whatever, she said, well, it had the consistency, or it looked like wallpaper paste, which is pretty consistent. And then she indicated that it was warm to the touch. In that case, the defense was, well, she's been exposed to pornography, so that's where she's getting this information. Well, that's not a fact that you're going to get from watching pornography. And so that is helpful for a jury to hear. We like to establish suspect opportunity. So is he somebody that takes care of you? Is it somebody that you have had the opportunity to be alone with? And then possible witnesses, like there was a case that we had where a little girl said that this only happened when her mom was at work and he was babysitting, mom's paramour was babysitting her and her brother. And later on, through the additional witnesses that we interviewed the brother, and he confirmed that there were times when mom was gone that he would be outside playing, come inside, and his sister's bedroom would be locked with the sister and the alleged perpetrator in the bedroom. So that is the type of information that we try to collect. Additional witnesses are interviewed. We had a case where a child indicated that mom's paramour forced her to watch the two engage in sexual activity, and she noted that when he would do this, the mom was always blindfolded, so she didn't know. So we went to the mom, we questioned her, have you ever engaged in sexual activity with your paramour blindfolded? And she confirmed that yes, she does. So that's corroborating information that we look for. There's additional investigation that pertains to the Pediatric Resource Center. Again, the child's taken there. There's a full medical exam that's done. So they're focused on the overall health of the child and not just doing a sexual assault exam. There is a sexual assault exam that's done, and the common misconception is that there would be evidence of trauma if a child was sexually assaulted. And we know for a fact that that's not true. And the way we know that is there are studies that have been done in which children, an 8-year-old is pregnant, or a 10-year-old is pregnant. She's made no disclosure of sexual assault. So all we have is we know she's pregnant. So we know that she's been sexually assaulted, and those exams, over 99% of the time will come back completely normal. And there will be zero evidence of any type of sexual assault or trauma to that area, which makes sense because of what it was created for, like childbearing and childbirth. In order to do that, I mean, one of the things that I remember growing up, ironically, one of my favorite shows was Law and Order SVU, and I remember one of the detectives saying, "Well, there's no way that this happened because there's no evidence of trauma. She doesn't even have a torn hymen," and that's just completely false. That's an inaccurate statement, and now it kind of drives me nuts. And it's a hill we have to climb, obviously, in jury trials in order to educate the jury a little bit that that's just not reality. We'll get lease agreements in order to prove that the family resided in a certain apartment when the child alleges that this happened. If that corresponds with the time that the child was a certain age, and that's the age that the child is indicating this happened, then that's corroborating information. photos of the suspect residence. Like before, I said if there's no reason that a child should be in a suspect residence, like going over to their piano teacher's house when it's not their piano lesson and they have no business being in that apartment, if they can provide descriptions of that apartment, and we are able to corroborate that by taking photographs, that is helpful information. Usually there's a suspect interview. Unfortunately, full confessions are rare in my line of work just because of the stigma that's attached to being a child sex offender. Sometimes they'll make minor admissions, but typically we don't get a full confession, unfortunately. There is an effort during that investigation or during that conversation with the alleged offender to gain factual information that's corroborating, like, what's your relationship like with her? If you establish that this is a good relationship that he had with this child, then the explanation, at the jury trial where he claims that the kid hates him and that's why she's making this up doesn't make a lot of sense. Were you ever alone with her? Did you ever watch her to establish an opportunity that he would have? What's interesting is typically the paramour indicates that in the 7 years that they have helped raise this child, they have never been alone with them. They've never had an opportunity. They've never taken them anywhere. They've never been in the bathroom with them. They've never bathed the child. And so that's suggestive that maybe there's something more going on here. It's not evidence of anything, but when they try to separate themselves that much from something, it kind of raises an eyebrow. And then ultimately, they forward it to the state's attorney's office after all of this is done for review of the charges. So that's how a case progresses through the Children's Advocacy Center process. Then the other side of the coin is the child pornography. So there's the National Center for Missing and Exploited Children. They work closely with a task force that's set up through the Illinois Attorney General's office, in which law enforcement participates in this task force. And then there's also the Pediatric Resource Center that's utilized in the child pornography type cases. And then again, saving the best for last, our office. So within the child pornography type case, the Illinois Attorney General's office has this task force, and they have a database system. And essentially, officers are trained in order to do this, but they're part of this task force. They get sent what they call a cyber tip through this database system, indicating that somebody is exchanging child pornography on the internet. You guys would be terrified to know how often this happens, and the fact that law enforcement really just cannot keep up with it. The amount of people within this community that are exchanging child pornography is insane. And it would be, if we had the resources available, we could have 5 to 6 state's attorneys that just do child pornography cases. That's how intense it is. So they go after the big fish, the ones that are exchanging a lot of pornography, which is a lot of them. So several images, the way this works is several images are reported by an internet service provider, and which is like Comcast Communications, Adobe Systems, something like that, and they provide the image that they believe is suspected child pornography. And that's if you're exchanging it through Snapchat. Yahoo is a common one that will report to the internet service provider. Rarely, sometimes Facebook likes to participate, but that's rare. And then what we do is we subpoena through a grand jury contact information. There's typically an IP address that comes with that image. So we send a subpoena back to the service provider of that IP address in order to get contact information, address information, phone numbers, date of birth, anything to tie that IP address to a particular individual. If they're corresponding through Snapchat or email or something like that, then we'll get a warrant executed on that entity to obtain that information directly from that entity. When we get that information back, they typically are able to verify through our local system the address of the offender, and they corroborate the information that they get from those subpoenas, verify that through our local system that this person actually resides at this particular address. Then they will seek a warrant to execute on the residence, and within that residence, obtained any type of electronic device, and then they will seek a warrant to search those electronic devices. These types of investigations typically take months because it takes forever to get through all those electronics. Then law enforcement will go through and identify the child pornography when they're searching the devices. Unfortunately, if you name it, there's a customer for it on the internet. There are some crazy things out there. Young children being forced to molest each other, male children being molested by women, which is rare, but you do see it. Bestiality, and then the most egregious, in my opinion, is toddlers or infants being penetrated, and that is not uncommon, unfortunately. When these images are identified as pornography, if it's clear, like infants or toddlers, we don't send it to the Pediatric Resource Center. But if it's unclear, there's two separate categories in which you charge child pornography: under 13 or 13 through 17. Those images will go to the PRC in order to define what category they fall under. And they obviously medically make expert findings on what it looks like, approximately how old the child is within those images. And again, we don't do it for any child that's necessarily under 5. Some of the problems I run into in order to charge some of these types of cases, if you have a child who is dressed in lingerie, but that lingerie is not transparent and there is no genitalia, pubic area, breasts that are exposed, and they in a video or dancing in a completely age inappropriate way, those are not things that I can charge. There has to be some type of sex act going on, or some type of nudity. Another problem I have is if a child as young as 5 years old, if she's in her underwear and she's twerking, which is common, and she's only wearing her underwear, under state law, if she does not have a partially developed breast, her breasts do not count as nudity. So those are unfortunately legal images. So then generally speaking, for any type of category within the office, the case gets referred for charges. We go through a grand jury and then seek an arrest warrant after the grand jury finds probable cause for the charges. Another way, which law enforcement, they have the opportunity to do, but they don't commonly do it because of how complicated these cases are. They can make a probable cause arrest and then send it to our office to make a charging decision. What complicates that is within 48 hours, regardless of weekends or holidays, they have to be in front of a judge with charges on file, or they have to be released. So typically we go through the grand jury. And then while there's pending case, it's my job to make an offer, tender discovery to the defense attorney. There's negotiation, there's motion hearings. A common motion hearing that we do is a motion to close the courtroom only in cases in which a child is on the stand and they are a victim of certain types of crimes. You can close the courtroom and kick out people that don't have a direct interest. The media is still allowed to stay. The defendant's family members are still allowed to stay. And then the child will have their advocate with them. They will be in the room. So we try to eliminate like the gawkers or the random people that like to just come watch this stuff, because that's weird. And I wouldn't advise it. It's not really a good time for anybody watching. And that's something that the state's attorney has been working on recently in order to, he's requested a proposal of legislation in order to allow us to close the courtroom even if that minor child turns 18. Unfortunately, a lot of these cases are pending for years. I mean, the piano teacher that the state's attorney just got done talking about that we tried together, that case has been pending since 2018. So those minor victims are now of age, they're 18 years old. And so unfortunately, we were in a position where we couldn't request a closure of the courtroom, so personal images of them depicting nudity were allowed to be displayed in open court. So Mr. Knapp has made an effort to propose legislation that will allow us to close a courtroom regardless of their age, as long as at the time that the offense was committed, they were minors, which is helpful in delayed disclosure cases. And then there's also, we either go to trial or they plead. It's rare that they plead because of the stigma attached to being a child sex offender. So typically, these are tried cases. And then unfortunately, a lot of people think at that point the case ends. In reality, it really doesn't. A lot of these people I'm going to be dealing with for decades, because then they file appeals, they file post-conviction petitions, they file clemency petitions, and it's never ending. And so we relitigate these cases for eternity, essentially, until the person passes away in the Department of Corrections, or their sentence expires. So all of this is possible, in short, because of the team that we have through the Children's Advocacy Center, the exceptional work of law enforcement, and then the support that I get through the state's attorney's office, not only with my colleagues, but also with my boss. There's little things that he does for us that help, that don't seem like it would be a big deal, but like when you're trying a murder case, he provides food to us so we don't have to worry about where we're going to eat lunch and dinner while we're prepping these cases or during trial. He also has tried cases with me, and he is probably the best researcher I know. So things that would take us a good hour to figure out, he's able to write essentially a brief within 15 minutes. It's actually remarkable. So there's a lot of legal research that he does for people in the office. And it's because of that support that we're able to be successful.
That's the most deference she's ever shown.
Never bite the hand that feeds me.
Do you have questions?
Short, that's everything. Does anybody have any
Now, I
questions?
did say, Glenn, can you throw that picture up real
Yes.
quick?
That's gonna
One of my
take, it's gonna
favorite
take me a
Erika
moment.
Reynolds stories, evidence.
Like I said,
You know what picture he's thrown up?
It's gonna take a moment.
So the Sidney Mays trial, the triple homicide, and one of the reasons it made a lot of sense for Erika to be on that case wasn't just because part of it was she was there that day and went to the scene, but a huge part of that trial was a 4-year-old boy who got shot. And Erika is great about eliciting testimony from kids on the stand, but it was a totally circumstantial case. We didn't have a gun. We didn't have two of the guns. There were two guns. We didn't have an eyewitness. The 4-year-old boy was in the room, could describe a few things. We didn't have a storyteller. We had a lot of gangbangers leaving the scene who all lied on the stand. And one of the things that we've won 10 murder cases in a row, but one of the things we had on that was an incredibly adept defense counsel. Does 10 murder cases a year up in Cook County. He's been practicing for 25 years and probably has 100 murder cases under his belt. So what I'm trying to get Glenn to throw up is this is, oh, you just had it.
Yep, I'm sharing it so the people at home can see it.
As Erika has delivered her closing, this is the defense attorney, and I'm sitting in the back watching this. You can tell how his case is going, and he tried a hell of a case. I mean, he did try a hell of a case, but Erika, with PowerPoint and everything, just tore it apart. It was, that's just one of my favorite pictures since
But props to him. He was a remarkable, probably one of the best that I've been.
And I think he after everything was said and done, he pulled Erika aside and said, "It's the best closing he'd seen in 20-some years of trying murder." So,
I'm sure that Mclean County has one of the highest or the largest amount of cases for a child in the state of Illinois, or?
Oh, I don't know about that. I just, the amount, I don't know if you're referencing my statement about the amount of child pornography within the community.
Or
I don't think that that is unique to
maybe
McLean County.
sexual abuse? Is McLean County pretty high?
I don't think so. I mean, I think that it's consistent. I don't have the actual numbers on that, but I don't see it being remarkably more compared to some of my counterparts. So I would say that it's consistent, unfortunately.
So about a month or two ago, I had a customer come in our store and he had to fix his phone. And he wanted it to be done very quickly. And just been talking to him, and I'm assuming this is real. Nice guy, he's a law enforcement, I don't know what task force he's on. But he said that he's assigned to these predators. That there are several of them in our community that are way beyond belief, that there are law enforcement that are just stationed to watch these guys. I don't know if that's true or not, but based on what you're telling me or what you've explained, you have to work with law enforcement of all different types.
Yes. I don't know that, I can't speak to this particular jurisdiction, but I am aware that situation exists.
These crimes are worldwide. We are fortunate that we have a great judicial system and people like you in our community and in our country. What's the rest of the world do? I mean, is it, third world? I just can't imagine there's any prosecution for these horrible crimes.
I mean, unfortunately, it's cultural in some parts of the world where this is accepted behavior. And so that is way above my pay grade.
Well, I mean, in Europe and many countries, there are certainly people like you that
Yeah, I mean, other established jurisdictions that this is obviously, I think that that's one of the reasons that there is such a stigma attached to it. I mean, because it is a problem that's universal everywhere. And so within established societies that I'm certain, I haven't obviously personally talked to anybody or anything like that, but like I said, it's way above my pay grade and I just focused on this area.
Is there a statute of limitations on the crimes against children?
So there used to be, and the sexual abuse in nature, there is not. There used to be. So if there's a case where a child discloses something that happened to her in the 90s, I have to go back and determine whether or not the statute of limitations has ever expired. And if it hasn't, then that's something that I can pursue. That's not uncommon. A lot of people think that a sex abuse survivor should report immediately and act a certain way. And unfortunately, that's the rarity that they will immediately disclose. So it's most of the time, it's 3 to 5 years delayed. Yes.
You had said that it could take a long time, to get go on. My question here is, if we have someone that has been put in jail, let's say 131 counts against him, I'm not gonna say any names, but are they allowed out on bail and then it takes years before you convict them?
Well, I'm not going to speak to specific cases that are
Right.
pending or anything, but they drive the train. They're entitled to a speedy trial with a certain amount of time. So they drive the time frame. It is rare that the state is able to obtain a continuance. There are certain exceptions where we're allowed to, but we have to justify that. And we're not in a position where we're entitled to say we're not ready. We're expected to be ready for a trial. So they drive the train on the time frame. There are times where I have stomped my foot, thrown a fit, looked ridiculous in court because I want something to proceed to trial, and they get to dictate that.
So
And everybody that's currently in our jail has bail. I mean, it's rare that bail can be denied, and that there's only certain statutory factors that entitle somebody to be denied bail. That's a rarity.
So, let me get this clear. So when they are accused, they're in, then they come out on bail. How do you, as a public, how do you know where things are going? Because you never see in the newspaper again. And it could be a high profile person or,
Well, our circuit clerk's office does a great job of putting cases on public access where you can follow them. And where you can go in and type in the person's name and up pops the case, and then you can follow where it's at and check in on it. Unfortunately, we can't do the reporting because we're, as the state's attorney's office, prohibited from making extrajudicial statements outside of court about pending matters.
But this is the place where a citizen can go and check.
Yeah, if you just like Google McLean County Circuit Clerk Public Access, up will pop a database and you can go in and type in a name and then you can follow the case.
And that person's still. Okay.